Good afternoon and welcome to the law. This is your legal light. It is your help law. And this week has been a lot of talk about Article 146 of the 1992 Constitution about impeachment proceedings of justices of the Superior Court, particularly the Chief Justice. So we're going to get some education learning. We'll learn about Article 146. What exactly is that, and how is the so-called Prima Facie done? So stay tuned for the best you can get. We'll open the phone lines very early for you to join with your thoughts. I'm Samson Lardi Anyenini. This is the law. It is your legal light. It is your help law. You're welcome back. So, as I mentioned earlier, we're just going to relax and have a conversation. Hopefully, that it will be a conversation that will improve your appreciation and understanding of the process of removing or impeaching a holder or the head of an independent constitutional body or a justice of the Superior Court. We just want to have an education. So you are clearly aware that there is presently an ongoing process that many dread and has brought about a lot of conversation in the country. It is about the petitions that have been brought forward by three people we do not know, we are not supposed to know, because the process, as we will learn in the course, is supposed to be in camera, because that's what the Constitution says. It has to be in camera. That means it has to be secret or it has to be private. It must not be open to the public. That is also raising another debate as to whether it has to be allowed to be that way, or because of the seriousness of this kind of issue, and particularly the people involved, the people whom we seek to protect by providing that provision in the Constitution. Perhaps it's the reason this process must not be shrouded in secrecy or privacy, but must be open to the public. That is coming up and being brought to the attention of the Constitution Review Committee, led by Professor H. Kwesi Prempeh. So let's begin, and I want to begin from here. I have some slides that I'll show with you as we have the discussion. But Article 146 of the 1992 Constitution, so like I said, just relax and let's have a conversation in this education talk. Article 146 comes under Chapter 11 of the 1992 Constitution. What is Chapter 11 about? Chapter 11 is about the judiciary. Article 125, that is under Chapter 11, says, justice emanates from the people and shall be administered in the name of the Republic by the judiciary, which shall be independent and subject only to this Constitution. Justice emanates from the people, and it shall be administered by the judiciary in the name of the Republic. And the judiciary shall be independent and subject only to this Constitution. This is the sense of justice, that justice is not anybody's, it is the people's. It emanates from us. So the people who sit in the court as justices or judges are administering justice in our name and on our behalf. But we want to protect them against unnecessary, disturbance and perhaps harm. So we say that we want them to be independent of everybody, independent of the executive, so to speak, independent of parliament, independent of everybody else, independent of the president. And they are subject, that is, they can be questioned only by this constitution. So, subject only to this constitution. Clause 2 of Article 125 says that citizens may exercise popular participation in the administration of justice through the institutions of public and customary tribunals and the jury and assessor system. I've hosted, our lady judges here, and we have had this discussion about how, because justice emanates from the people, you are also entitled and given the room to participate in the justice delivery system. Not only as a complainant or a plaintiff or a defendant or, say, an applicant or a respondent to a matter. No. Not only as a party in a matter that a judge has to take care of, but also as somebody who sits in the courtroom and decides the fate of people. Decides the fate of people. And that can be done through the jury and assessor systems. And 3 says the judicial power of Ghana. I'm getting to a point. The judicial power of Ghana shall be vested in the judiciary. Accordingly, now we want to emphasize the independence of the judiciary. Accordingly, neither the president, nor parliament, nor any organ or agency of the president or parliament shall have or be given final judicial power. So everything we do in the realm in this country, you can say that the buck stops with the judiciary. When there are misunderstandings, when there are differences, when we cannot solve our problems by ourselves, and when we are found not to act in accordance with the dictates of law, the Constitution, and the thousands of other legislations that have been made that's supposed to guide us in society. It is the judiciary that will whip us into line. Yes, through law enforcement. That's why you commit a traffic offense and the police arrest you. The police, when they arrest you, they can't beat you, they can't hit you with a stick. They don't have the power to do so. They can't take a gun and shoot you. They can't do that. Why? Because the Constitution in chapter 5 protects your life. It says your life and your dignity is inviolable, and you have a right to life. It's the reason nobody can just get up, and run into your home this afternoon, wherever you are sitting. Nobody can just get up, come, hit your gate, break it up, and enter and go scot-free. We don't live in a jungle. We live in a decent human society, and it is law that orders everything that we do. Without the law, things may go in a different way. In clause 4 of Article 125, it says, the Chief Justice shall, subject to this Constitution, be the head of the judiciary and shall be responsible for the administration and supervision of the judiciary. The judiciary shall have jurisdiction in all matters civil and criminal, including matters relating to this Constitution and such other jurisdictions as Parliament may by law determine. So, once we did this in the Constitution in chapter 11, which begins with Article 125, then we provided for how the judges will be appointed to administer justice in our name and for us. So at Article 144, you find appointment, retirement, removal of justices of superior courts, and chairmen and other members of regional tribunals. So the judges have to be appointed into the various courts. How is that done? There's a process how that is done. And once they are appointed, they must have terms and conditions to serve. And the terms and conditions include how their independence is protected and they cannot be removed at the whim of anybody. Remember, they are not subject to the president and not even parliament, except maybe in their expenses and the things they do, their budgets. Of course, parliament has oversight over the purse or the public purse. So, say one has to qualify to go to the High Court. You must have been a lawyer, and you must have done 10 years as a lawyer. That's the first qualification. But of course, you must be a person of, high moral character and proving integrity. A person of high moral character and proving integrity. We're getting to a point. This is important to get you to why removing a judge ought not be easy. And if they sin against the terms and conditions of their office, how serious it becomes. So judges are supposed to be persons who are of high moral integrity and moral character, of course. Now, once the appointment, retirement is provided for, then how to remove them is also provided for in the Constitution. If someone wanted to be a judge in the Court of Appeal, they must have been a lawyer for at least 12 years. If they want to be a judge in the Supreme Court, they must have been a lawyer for at least 15 years. That's just the number of years you must be as a lawyer in good standing, but you must have a high moral character and proving integrity. That means there's no dent on you. So let's note that. Now, once we have gone through the process to appoint you to become a judge, and the judges from the High Court to the Court of Appeal to the Supreme Court, we say they are justices of the Superior Court of Judicature. There are other judges who are below in the Family Tribunal, in the District Court, and then in the Circuit Court. They are below. There is a process. If they have to be removed, it has to be gone through. But for those in the High Court going up to the Supreme Court, including the Chief Justice, if they conduct themselves in a way that warrants being removed from office, then Article 146 will kick in. So let's begin the conversation. What is Article 146? And follow me on the screen as I take you through just call it the basics of what constitutes Article 146. So Article 146, once again, is found in Chapter 11 of the 1992 Constitution. And it is an extensive 11-clause single article. So it's one article, but the clauses are 11 in all. And it is under the terms and conditions of the service of a Superior Court judge. And more specifically, it details the procedure for removal from office of justices of the Superior Court, a point I've already made. Now, this same procedure has been extended to commissioners of independent constitutional bodies, including the Commission on Human Rights and Administrative Justice, SHRAJ. So the commissioner for SHRAJ, the deputy, they are all subject to this process. If you want to remove them, this is how the process you can go through to remove them. So they are supposed to also enjoy some security of tenure. So that's simply what it is. We have created the Office of Special Prosecutor. So the Office of Special Prosecutor has also been brought under Article 146 because to qualify to become the Special Prosecutor or the Deputy, you must be a lawyer of 12 years standing, high moral character, proving integrity, and the deputy must be, up to the High Court 10 years. Do you get that? Yes. To qualify to be a justice of the High Court. Now, because of that, protections we are conveying to them, remember that all these appointments, they are done through the president. There may be bodies like the Council of States. There may be bodies like the Judicial Council, okay, that may help in the process. But the appointing power ultimately rests with the president. These bodies could offer advice or could be bodies that will be consulted. And sometimes even Parliament is brought in for, and you have seen justices of the High Court being, justices of the Supreme Court going through vetting process in Parliament as part of the process to check all of these. Because the president is the one that appoints these people, the wisdom has been that if they have done something wrong and you want them to be removed, the president must be giving notice. He must be made aware that the person he appointed or she, the president appointed, have done some wrong. They have committed some sin and they have to be removed or go through a process to be removed. So that's a courtesy that we are according the president. So the requirement is that you have to send a petition. Petition is simply a complaint. And you are sending the petition to or through the president. There's a reason I say to or through the president. So Article 146, Clause 3 simply makes the president a conveyor belt or a postmaster. Conveyor belt. We are familiar with conveyor belts or a postmaster. Unless the petition is against the Chief Justice. The T is missing in what I put up there. Unless the petition is against the Chief Justice. And the Constitution in this article says, clause says, if the president receives a petition for the removal of justice of a superior court other than the Chief Justice, or for the removal of the chairman of a regional tribunal, which is also a court, he shall refer the petition to the Chief Justice, who shall determine whether there is a Prima Facie case. That is clause 3. Petition. So you send a petition. Now, I'd like us to skip the Prima Facie determination that the petition has to go through before it will qualify to be looked into. I'd like to skip that and go to my next slide. So the complaint is not any complaint at all that will be entertained, because these are persons who occupy important offices. They are constitutional, independent constitutional offices, and so they deserve protection against frivolous matters. They deserve protection against, a jilted companion wanting them to be removed. So what qualifies as a petition for the removal of an Article 146 subject or individual? Article 1, the provision circumscribes the nature of complaints to be entertained. So it says, a justice of the superior court or a chairman of the regional tribunal shall not be removed from office. So a justice of the superior court or a chairman of the regional tribunal, you can put in the head of SHRAJ or their deputies, head of NCC or their deputy, head of EC or their deputies, the SP, special prosecutor or the deputy. They shall not be removed from office except for stated misbehavior, or incompetence, or on ground of inability to perform the functions of his office, arising from infirmity of body or mind. So stated misbehavior will be in the nature of the person having so misconducted themselves. It's misconduct, which is supposed to be seen to be grave misconduct. It's a sin that somebody commits. Many of you go to church and to the mosque, so you like to use a sin rather than misbehavior. So misconduct, which is grave. You have been put into such a high office. There are certain things that you cannot be seen to do or you must not be heard to do. If you are embezzling funds, if you are involving in corrupt activity, right? If you are perhaps engaging in very serious, say, sexual offenses, then you will be caught by stated misbehavior in that particular office, and you are not qualified to continue to hold that office. So the petition must not carry frivolous claims. It must carry serious, complaints of something that one has done wrong. Or it says incompetence. Incompetence. You've been put into the office, but we can see that the things you are doing, they give suggestions, they give us impressions, or they give us clear indications that you're really not qualified for that office. You are incompetent, right? You are taking decisions that go contrary to that office that you are supposed to hold. The laws and the rules that mandate the things you are supposed to do. Then, if it's not about misbehavior or incompetence, then it must be about your inability to perform the functions of your office. And what will cause that inability? Infirmity of body or mind. Infirmity of body simply means you've become ill, and you are so ill that you are unable to continue to do the work, and yet you are still hanging in there. So we have to find a way to remove you. You are ill, terminally ill, and you are unable to just perform your job. So that is infirmity, of body, so to speak. Then there is that of the infirmity of the mind. Also will be a medical condition, just as infirmity of body will be a medical condition that, you have become incapacitated somewhat. You're suffering some mental situation, and there must be medical proof that the person is suffering this, and because of that, they are unable to do their work, and yet they want to hang in that office. Then you can trigger Article 146 by a petition or a complaint to the president, who is a conveyor belt, unless it is about the Chief Justice, and the process will begin. Where the petition is for the removal of the Chief Justice, the President shall, acting in consultation with the Council of State, appoint a committee consisting of 2 justices of the Supreme Court, one of whom shall be appointed chairman by the President, and 3 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers. This is Clause 6 of Article 146. But we will skip this because we need to come back to this. We have skipped Prima Facie, and we're skipping, when it has to be about the removal of the Chief Justice. Now, when it is about the removal of a justice of the Superior Court or the independent constitutional body, so to speak, we have an 18-member Judicial Council that plays a significant role in the Article 146 process, especially in advising the Chief Justice to appoint certain members of the panel and also advising for the suspension of a respondent, that is the person who has been accused. And it's a serious constitutional body provided for in Article 153 to comprise the following persons. There's a Judicial Council. So there is headed by the Chief Justice, the Attorney General is there, a Justice of the Supreme Court is there, a Justice of the Court of Appeal is there, a Justice of the High Court is there, and then let's move forward on the slide. Yeah, there are two representatives of the Ghana Bar Association, one of whom shall be not less than 12 years standing as a lawyer. That's somebody who is qualified to be in the Court of Appeal. A representative of the chairman of regional tribunals nominated by the chairman. There's a representative of the lower court. I've told you about the lower court and tribunals who are not Superior Court judges and so are not caught by this particular article. They also come into this situation. Then there's a Judge Advocate General of the Ghana Armed Forces. The Ghana Armed Forces has, a sort of a quasi-judicial thing that they do among themselves to ensure discipline over there. The one in charge is the Advocate General. Then we have the head of the Legal Directorate of the Police Service, who also joins the Judicial Council. We have the editor of the Ghana Law Reports, a representative of the Judicial Service Staff Association, a chief nominated by the National House of Chiefs, and 4 other persons who are not lawyers appointed by the president. Let's stay with when the president is merely a conveyor belt, or what I call the postmaster. So you take the petition, you take it to the Jubilee House, the receptionist will take the petition, they put it down, the petition is sealed, your name is on it, you have signed it, it is nicely dated. You can do it yourself or you can let a lawyer do it for you. So the petition is a complaint, it's a piece of paper you have written what offense you think has occasioned it. And then you could also add to it, some documentation that prove that the things you are saying are true. For example, that, a person who is in this office, subject to this provision, they have amassed wealth, that you think that the wealth they have amassed, they have done it through a corrupt process, and you can trace the act of corruption that the person has been involved in, and there is some documentation that is involved. You can put all of that together and add it to the document and send it. At the reception, they will take it, they will stamp it on the date of receipt, and then they will go and give it to the president. Once it is handed to the president, remember, if it is not about the Chief Justice, the president will receive it, and then by law, he is not supposed to do anything about it. He's supposed to forward it. That's why I say he's a postmaster. He's just a conveyor belt. He's conveying, to the next person. And who is supposed to receive it? The Chief Justice. It goes to the Chief Justice. The Chief Justice receives it, and the Chief Justice is supposed to do what we call a Prima Facie determination. That is, look at the documentation on its face. Look at the claims that you have made. Are they weighty? Are they matters that go to stated misbehavior, that is misconduct? Are they matters that go to incompetence? Are they matters that speak to, with evidence, that speak to incapacity or inability to perform the function because of infirmity of the body or the mind, right? The Chief Justice will make that determination, and once he or she makes that determination that while a Prima Facie case has been made, and we'll deal with Prima Facie shortly, a Prima Facie case has been made, then she, together with the Judicial Council. I have taken you through who constitute the Judicial Council already. She, together with the Judicial Council, will now set up a 5-member committee. It's a panel that will do the probe. A 5-member committee that will do the probe. And this 5-member committee, as I've already mentioned to you, this is what the law says, that where the Chief Justice decides that there is a prima facie case, he shall set up a committee consisting of 3 justices of the Superior Court. 3 justices of the Superior Court. Remember, I've told you who are in the Superior Court. Or chairman of the regional tribunals, or both, appointed by the Judicial Council, and 2 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers, and who shall be appointed by the Chief Justice on the advice of the Council of State. So there are those who must form part of the committee to do the probe. They shall be appointed by the Judicial Council, 3 of them who are judges of the Superior Court. And then there are 2 other persons who must not be members of the Council of State, who must not be members of Parliament, and who must not be lawyers, and who shall be appointed by the Chief Justice on the advice of the Council of State. So 5-member. Then they will sit, the committee will sit, they would look at the complaint. They will invite the person who has been accused. Shraj boss Loretta Lamte was accused. I did that case for Richard Nyama, who raised the concerns, and we filed the petition to the presidency, and the presidency forwarded it to the Chief Justice Georgina Wood, and a prima facie case was made, and then she was invited in. So she comes in with her lawyer, then you, the complainant, also go with your lawyer, or if you have some expert that you want to use to help your case, the law allows you to do so before the 5-member panel or committee. So that is done, and it goes through like a normal court process. How a trial is done, you make your case, the one makes their defense, they cross-examine people, question them, they look at the evidence and to establish if they are weighty enough to merit the removal of the person from office. Now, once they are done with that process, then the committee will do a recommendation. They will do a report and make recommendations. If the committee recommends that the person is guilty of the offenses that have been raised, then they will ask the president to remove the person. If the committee recommends that the person is clean, the allegations are not weighty, or that they have not been proven, then they will advise and recommend that the person should not be removed from office. And the president does not have an option. He can't say the committee's report recommends that Charlotte Osei should not be removed from office, or her 2 deputies who were petitioned against should not be removed from office. But he, the president, thinks that the committee report is not good enough, so they should be removed from office. The president cannot do that. So this is the process when it is not about the Chief Justice and the president is merely a conveyor belt. But when it is about the Chief Justice, and all these processes, they go on, as the law says, in camera. That is in Clause 8 of Article 146. Clause 8 says, all proceedings under this article shall be held in camera, meaning out of the view of the public. Private, it must be confidential. Now, it says in camera, and the justice or chairman against whom the petition is made is entitled to be heard in his defense by himself or by a lawyer or other aspect of his choice. Then clause 9 says, the president shall, in each case, act in accordance with the recommendation of the committee. Now, as it happens with us in our various offices, I'm going to open the phone lines very soon. We will take time on Prima Facie. We'll deal with it. But I'll open the phone lines very soon and take your views and your comments as well. And as the process goes on, as we all undergo in our places of employment, perhaps, when accusations are made against you, you may get a query, things happen, and you may get interdicted or suspended, pending the determination or the disciplinary process. When it is finished, then if you are found not to be guilty, you can be brought back, and if you have stayed home for 6 months without pay, 6 months with half pay, normally you'll get a reimbursement of what you lost, and so on and so forth. This also applies here. In Article 146, Clause 10, it says, where a petition has been referred to a committee under this article, that means the petition has crossed the important threshold of prima facie. The President may, in the case of the Chief Justice, acting in accordance with the advice of the Council of State, by warrant signed by him, suspend the Chief Justice. So presently, as we understand, there is a prima facie determination that is about to happen in respect of the 3 petitions against the Chief Justice. If that prima facie determination is made in the positive, affirmatively, positively, the President may suspend the Chief Justice, but he has to do it acting in accordance with the advice of the Council of State. Now, if it's about anybody else but not the Chief Justice, Article 146, Clause 10b says, in the case of any other justice of a superior court or a chairman of a regional tribunal, acting in accordance with the advice of the Judicial Council, suspend that justice or that chairman of the regional tribunal. So you see how it goes. Thank you. So this is what happens. Now, let's go back to the thorny issue of the prima facie. And in the next 5 minutes, I'm opening the phone lines. You can join us. And so we have conversations about this Article 146 process in the next 5 minutes. So, prima facie, what is it? You have heard it over and again. Everybody's saying prima facie, prima facie, prima facie. What is it? It's a Latin word. Prima means first. Prima means first. Facie means on the face. Okay? Prima facie. So, prima refers to first, and facie means the face. So, when you are doing a prima facie, it simply means you are going to look at the petition that has been brought to you. It's paper or documents that have been brought to you. So, you simply just read through it. Yeah, prima facie, on the face, first impression, right? That's what it means. Your first impression of what you are seeing. So you look at it. This is coming from Nikote. He says his address is P.O. Box so and so, or his house is here. He has signed it. The date on it is this, and he addressed this petition to me, the president. Me, the president. Me, the president. And I can see the things he's talking about. He says that the EC boss, during the election, met with some people, and he has a video of it. He met with some people, and the people he met with, they were planning to rig the elections, and I have the conversation. In the conversation, he took 100,000, US dollars, and the US dollars that he took also, that's the EC boss, he, took. And I know how the money was wired to him. It was wired to him by the chairman of the Brookman Association Party. And it went through, Kokomlemle Rural Bank into his account in Sakasaka, bank. This is the bank account. This is his bank, details. And the money went there. 10,000 US dollars, was paid. Oh, really? And this is the bank account. I've seen the bank process, the statement. Whoa, I have seen the conversation purported to be the voice of the EC boss and the people who are in the conversation, and they were making a conversation to rig the elections. This is gross misconduct. An EC boss cannot conduct themselves this way. Completely wrong. Yes, so on the face of it, I can see, and I've seen the evidence. This is so wrong, and it's corrupt conduct. On the face of it, it's looking at it and seeing, this is what's going on. Okay. If it is not about the Chief Justice, remember, it's not the President with the Council of State who will do the Prima Facie determination. Even that, will come to that. So it is the Chief Justice who will do that. Look at it and say, I have found that this is credible on the face of it. Let me call the other person. Let me set up a committee and let the other person come and defend themselves and prove that these claims are not true. So that's Prima Facie. First impressions. The Oxford Law Dictionary defines Prima Facie as evidence that is sufficient to discharge the burden of proof borne by a party, and that may be sufficient to discharge the persuasive burden of proof if no evidence in rebuttal is tendered. Meaning that evidence that has been submitted, if there is no evidence to the contrary, will it be okay to stand on to dismiss a person? Yes. Will it be okay to prove the case or the allegation that is being made? Yes. There are bank transactions showing the bank account and all of that, So then 2, it says, Prima facie evidence is evidence of a fact that is of sufficient weight to justify a reasonable inference. It's not conclusive. A reasonable inference of its existence, but does not amount to conclusive evidence of that fact. Meaning, once the CJ looks at it and says, Prima facie has been made, first impression, I think this has to be gone into. Then the committee is set up. The 3 Superior Court justices appointed by the Judicial Council, the 2 who are not lawyers, who are not members of the Council of State, who are also not MPs, appointed by the Chief Justice with the, on the advice of the Council of State, are brought in, sit down. Then the person comes in, the EC boss that is being accused, comes in and then brings the evidence and goes through it. You say, yes, the voice in there is not my voice. Now let's go through the program. Let me show you why it's not my voice. Then they will show and say, oh, this may be an AI done. It's not really that voice. They would have checked it. Okay, the bank account too. The person who paid and the bank, is it not your bank account? They call the bank people. They may come in and explain that, yes, this person is called Techi Mensah. The EC boss is also Techi Mensah, but it is not the EC boss Techi Mensah. Then we say, oh, the thing that we thought is the EC boss is not the one. So case is thrown out. But if it is found that is really the person, then they will be found to have been done the wrong and they will be dealt with. Now let me open the phone lines now. Join me for a conversation. As you are joining, we'll continue to talk about the Prima Facie. So call now. The phone lines are active, advertised. This is the law. It's your legal light. It is your help law. The debate over the Prima Facie has been this. Is the president required to make a Prima Facie with the Council of State before the CJ, before a committee is set up for the CJ to be heard? Article 146, Clause 6 does not say that the president, in consultation with the Council of State, should make a prima facie determination before the CJ is invited. So in 2005, 2006, somebody went to court about a similar issue. And the court said there should be a prima facie determination before the committee is set up by the president and the Council of State. Right. Gabriel, thanks for joining us. What's your question? What's your contribution?
My question is that...
Hello, Gabriel, go ahead.
Okay, my question is, now we have learned that three petitions were submitted to the... petitions were sent to the president.
That's correct. 3 petitions, correct. Go ahead. Hi, Gabriel.
Yes, so please, I want to know if the president is basing on the 3 petitions or just one of the petitions.
Right, thank you very much. Who is next? So Gabriel wants to know 3 petitions. Which one should I use or all? Hello, Gideon. Hello, Gideon. Gideon, you are hanging in there. Quickly.
Good afternoon.
Yes, Gideon, go ahead.
Yeah, so I am asking what is happening now. So the president is not supposed to forward the Prima Facie case to the Chief Justice, if I understand the whole thing.
Thank you for your question. I'll answer it. Who is next? Hi, Lincoln. Lincoln, let's hear you.
Yeah, good afternoon, Attorney. I'm just praying that whatever is going on, it should not be political motivated, but for the love of Mother Ghana. Because if it is political motivated, we don't know what the future holds for we, the youth of this country. It will set a bad precedent for us.
Thank you, Lincoln. So, Lincoln, this is the law. On the law, we try as much as possible to stay away from what is politics and just have education and learn. So, I have taken the 2 questions that I'm going to respond to. Should he deal with the 3 petitions? Is the president, under obligation constitutionally to forward the petitions to the CJ or not? At what stage? That's a big question. Who is next? Hi, Yusuf. Yusuf. Oh, no. I think I lost Yusuf there. So let's continue whilst we wait for Yusuf to call back or whoever is on the line to get in. So when it's about the Chief Justice, it's Article 146, Clause 6. 146, Clause 6. We can read that again. We can put that back on the screen and all of us shall read it together. It says, where the petition is for the removal of the Chief Justice, the President shall, acting in consultation with the Council of State, appoint a committee consisting of 2 justices of the Supreme Court. It didn't say Superior Court. It says Supreme Court. So they must come from the Supreme Court. 2 justices to be appointed by the President in consultation with the Council of State. Then they will appoint they will also appoint one of that person will be designated by the president as a chairman. And then there'll be 3 other persons who are not members of the Council of State and who are not members of Parliament or lawyers, who the president together with the Council of State will put together to deal with a petition concerning the Chief Justice. Question: should they do prima facie before? Should they have the Chief Justice bring her views before? What happens? In here, you can see that they don't say that, the Constitution doesn't say they should do a prima facie. Unlike the other ones, where it is very clear that that's in Clause 3. Clause 3 says, if the President receives a petition for the removal of a justice of the Superior Court other than the Chief Justice, or for the removal of the chairman or of a regional tribunal, he shall refer the petition to the Chief Justice, who shall determine whether there's a prima facie case. That's Clause 3, about any other person who suffers this process. But in Clause 6, they don't say there must be a prima facie. So I said in 2005, 2006, there was a case. It's called J. Chum. You know, Abratakwete versus Attorney General. And the Supreme Court does what you call filling in the gaps when the law is not clear during the interpretation of the Constitution. And the Supreme Court said there must be a prima facie case done for the Chief Justice also before a committee will be set up. That is settled. I've gone back on an emphasis. We'll come back whether the view should be taken or no view should be taken. Vincent, where are you calling from? What's your question?
I'm calling from Sunyani.
Yes, Vincent, quickly, let's hear you.
I'm Vincent. My opinion, to me, the Constitution is very aged or outmoded. From 1992, we need to amend the Constitution. And my question is, the matter is of public interest. Why should it be held in camera?
Okay, so you want it to be
question.
public. Okay, thank you very much. Prosper, you're calling from who? What's your comment, question?
I have a question. So I wanted to know if a petition can be sent to the president and the person will...
Prosper, I'm not hearing you. Speak loudly.
So my question is, can a whistleblower petition the office of the president to oust the Chief Justice from office?
Sorry. Say that again.
Can a petition be sent to the president as a whistleblower to oust the CJ from office?
As a whistleblower?
Yes.
Yes, you send a petition. The law says send a petition. So you send a petition. That's all. Once you send a petition, I have told you what qualifies as a petition for removal of somebody from office. It must not be frivolous. It must speak about stated misbehavior, misconduct, something grave that they have done, or that they are incompetent, and you must show why you say they are incompetent for that office. How have they conducted themselves in the office that you say they are incompetent? You must show by medical proof that they have, an infirmity of the body or the mind. They are ill and they can't perform anymore, or that they have a mental situation and they can't perform anymore. That's medical, so that's easy to prove. You need that before you can cross the threshold for the person to be, the petition to be worthy to be considered. For example, when I was doing the petition against Loretta Lamte for Richard Nyama, there were several petitions that were sent, but the petitions were thrown away. It was one petition, my client's petition, that was upheld, and that was eventually heard. So that's how it is done. Now, when the petition is about anybody other than the Chief Justice, the Constitution in Article 3 says there must be prima facie. Chief Justices over the years, what they do is that they say before they make the prima facie, they want to invite the person who is accused to bring their response before they make the prima facie. So they will invite you, bring us your opinions. Let's know what are your reactions before we make the prima facie. There's one situation, though, that we know that the people or one person complained that they had not been given. In Charlotte Osei's case, she had written, and I still hold that letter with me, where she wrote to the Chief Justice and say, give me a copy of the petition so that I'll give you my ideas, my views, my reactions before you make the prima facie determination. And she didn't have it. She was not giving it. But the thing is that if you are not giving at that stage, it doesn't mean you will never be giving. Once the committee is set up, if a prima facie case is made and the committee is set up, you will be giving a copy, and then you appear before the committee, you write your response or bring your evidence, and that evidence is used. In the Constitution, for the Chief Justice, it didn't say there must be a prima facie. It took the court, the Supreme Court, to say there must be a prima facie. Then, later on, in another case we call Utaderi, the judges made what we call advice, which is not binding because it's not what we call the ratio. In law, when a decision is made like by the Supreme Court or any other court, what we look for is the ratio. What was the main thing that the court decided on? This was not the main thing that the court decided on. So the court made what we call side comments or advice and said, if it's about the person, let them hear them before you make a prima facie determination. But there's a view that says you don't need to hear the person first, because prima facie is presumed, it's inconclusive first impression. Then when the hearing itself is going to be done, there will be the opportunity for the person to now bring their, thing. Now, in respect of the CJ wanted to have a copy and said that is a breach. The presidency or the Council of State together with the president have now forwarded a copy to her. She will write a response, they will look at the response and then make a prima facie determination. If it is positive, then she'll be invited to a committee that will be set up, and then the committee will go through it. In 2005, 2006, in that case, the court said there's a need for rules to guide this process. I believe that it is far time we have those rules. When we were making the OSP law in 2017, we put in specific timelines for everything to be done. If you file a petition against the OSP, it goes to the presidency. Within 7 days, the president must forward it. People have been filing petitions to the presidency. The presidents don't forward it. They throw it away. You must do that. The Chief Justice have 30 days to make a prima facie, 14 days to set up a committee, 90 days for the committee to bring a decision. We need this now. As for whether it should be in camera or it should be public, the jury is out there. This has been the law. It's your legal light. It is your health law. I'm Samson Lardi Anyenini. Have a good afternoon.